Here.
Clemens.
Yeah.
Kate Sabatini here. Commissioner Parry is absent. Robert Baum is absent. Courtney Hawkins is absent. Justice Hughes. Sean Curlin is absent. And Mark Gibb is, yes, present and not absent.
Thank you for coming out tonight. Madam Clerk, let the record reflect that Nick Freeman from the council office is here, and Sue McKenna.
So noted.
Thank you so much. Would you be able to read, why don't we read both items, then we can open the discussion.
Discussion relative to the proposed ordinance establishing Chapter 18 and the Code of Ordinances, Community Safety Act, Section Searches, subsection 2. Discussion relative to the proposed ordinance establishing Chapter 18 and 4 of the Code of Ordinances, Community Safety Act, Section F, Surveillance and Privacy, subsections 2, 5, 8, 10, and 15.
Thank you. Okay, everyone. So, seems like when we were going over the agenda on Monday, things were going pretty smoothly in the format that we did it. So, why don't we continue along with that tonight? So, if you have anything you can pass up for us for discussion points on the agenda? Sure.
Mr. Chairman, again, for the record, Nick Freeman, Manager of Policy and Research, Office of the Providence City Council. At the last meeting, I handed out these, which are the sections of the Community Safety Act that are largely, generally agreed upon, are not going to appear on the agendas for this working group. But I printed out a bunch of them again today, just in case anyone didn't have them with them, or if they wanted a copy. I know the chief wasn't with us last time. Now there's justice, I believe. So, got those printouts for you. They're there. The other thing I'm going to hand out is similar to what I did at the last meeting. I've pulled out the exact language of the sections that are being covered on today's agenda, and I've got copies of that written here on this one page.
Great.
If that makes it easier to follow.
And Madam Clerk, if you could please designate the larger item as Exhibit A.
So noted.
That was already marked at the last meeting. Okay. Then what we'll do is we'll mark the handout in regards to this agenda as Exhibit A for tonight's meeting.
So, just like I did at Monday's meeting, I'm just going to walk you through the discussion points that will come up with the fraternal order of police in the course of this. And I also want to mention Sergeant Bone, the president of the FOP, was here earlier, but he had to leave early. He had to leave because of family emergency came up. So, I just want to put that out on the table for everyone. So, the first agenda item is under Section E, Searches, subsection 2. I just want to draw your attention to the line in the middle of the paragraph there where it says, individuals who identify as transgender or gender non-conforming have the right to indicate their preference to be searched by either a male or female identified officer.
Yeah, Madam Clerk, please let the record reflect that Shauna Curlin is present.
So noted.
So the concern in that line right there that Sergeant Bowman brought up to me was about the phrase afterwards as male or female, it says identified officer. And his concern was that putting police officers in the position of them having to identify as either male or female gender identity themselves. And there was concern about putting them on the spot the same way that earlier renditions of this ordinance had put the person being searched on the spot. With that in mind, the suggestion that came from the Fraternal Order of Police was to simply strike the word identified there so that it would read instead, individuals who identify as transgender or gender non-conforming have the right to indicate their preference to be searched by either a male or female officer.
Does everyone see what that is in the handout? So it's midway down in the top paragraph. That's there's a paragraph that's labeled number 2.
So I don't think that changes the intent of this whatsoever. It gets to the same goal that we had in earlier versions of this. It's just about trying to deal with that concern on the FOP side. So, would you like me to keep moving through the agenda, or should we open a discussion on that point first?
Why why don't we keep moving? And then we can talk about everything, unless someone has an immediate question with anything that Nick is going over, okay?
So, moving on to 2, everything here is underneath section F, surveillance and privacy. The first place here that we're looking at is 2, where it says police may not engage in an undercover capacity with groups in non-public places based solely on the exercise of First Amendment rights. Sergeant Bowen had suggested that after having some discussions with the FOP's legal counsel, there was a concern about the way that's phrased, just saying First Amendment rights. And the suggested change that they brought to us was to change it to say, based solely on the exercise of First Amendment protected activities. Again, I don't think this changes the intent or the goal here. If it clarifies something on their end, that's the goal there. And Kate, you and I spoke earlier today about what the implications that might be. I defer to you in terms of that. Moving on down, the next point would be 5 underneath F, surveillance and privacy. Here, I was just trying to clarify this because the way that it reads, there's sort of 2 parts to this provision. It says police may not photograph individuals under 18 years of age, or in the event that age identification cannot be confirmed, individuals who appear to be under 18 years of age. So, because the second half talks about when you can't confirm their age, the FOP had asked that we change the first part of that to read, the police may not photograph individuals confirmed to be under 18 years of age. So that way it's about confirmed or not confirmed, it's clear throughout. Again, the intent here, the implication of how it's going to work on the street isn't to change, just to make it clear within the provision itself how this works. Moving down to 8, underneath surveillance and privacy. So that's flip over the page. Under there it says, no police officer shall identify any individual as a member of a gang in a list or database maintained by any law enforcement agency, nor in any written notes, reports, memoranda, or other document without identifying criteria for inclusion on a so-called gang list or gang database that may apply to individuals. So, on this section, the goal here was to make sure that when the police department refers to someone as a gang member, they're referring to someone who meets the criteria to be on the gang database and not otherwise. But in conversations with the FOP and some of the concerns that were brought up from their rank and file, there was a concern the way this is written, it's going to end up micromanaging and get written notes when they're out in the field. And so the suggestion there is to scratch written notes. The idea being that they were concerned that they might inadvertently violate the CSA because on their own handwritten notes in the moment, they say 3 possible gang members and only 2 of them are on the gang list at that moment and the 3rd one isn't. They didn't want that to lead to an unintentional violation of the CSA. So removing the written notes from this would take away that sort of micromanaging feel. The other thing in this was there's a question of, well, what if you refer to someone as a possible gang member, or based on something that's been observed in the field, an officer says, well, maybe we should be having more investigatory activities on this person to see if there is a connection to gang activity. So to clarify that and make it simpler here, I was going to suggest that we add a line to the end of this section, and I think we can play with this, and again, I'll refer to the attorneys in the room about how this should be phrased, but the language that I come up with was, nothing in this section shall be construed to prohibit officers from referring to individuals as possible or suspected gang members, or from indicating the need for further investigation of potential gang activity.
Can you say that again?
Yeah, I'll read it slowly, I'm sorry. Nothing in this section shall be construed to prohibit officers from referring to individuals as possible or suspected gang members, or from indicating the need for further investigation of potential gang activity.
We'll be able to read this again, okay? So when we're bringing this back for discussion, we'll make sure that everyone has the wording for it, okay?
Moving on down to the next subpoint was 10 underneath this, and this is the gang listing database. I wish the sergeant was here at this point right here, but it didn't sound as though they're concerned with any specific language underneath this point, but more about the fact that throughout this ordinance we're referring to Providence External Review Authority, Providence Civilian Review Board, and giving them more authority relying on them for reviewing policies, those types of things, and here specifically doing the database appeals. That having been said, I think we're all aware that PARA currently is inactive. It's been dormant for many years now, and basically I think we're starting to want to raise a discussion of how do we address that problem instead. It's incumbent on the city, if the CSA passes, to then deal with the PARA part of it. So I think that was more sort of a discussion point for us to talk about what the path forward on PARA is going to be. And then the last thing on the agenda for today is subpoint 15, and I think this is a very reasonable well-taken point. The intent of this was about the audit of the gang list. There's going to be an independent auditor who then releases a report on the audit to PARA every year. The intent in this section is never that the individual names of people on the gang database or on the gang list would be part of this report. But there was a concern when people read this section that it doesn't explicitly say that the names are not in there. So I was going to suggest that we add in a line that says, in the auditor's report, the names of individuals on the gang list shall not be included and shall instead be replaced with unique identifying numbers. So if Nick Freeman is on the gang list, then in the report, they're making reference to me, it doesn't say Nick Freeman, it says gang list member 1, 2, 3, 4, 5, and then whatever other information is in the report. Just so that way the gang list stays private and names don't just come out. And I think that takes us through the whole agenda.
Okay. So, just as a recap, it seems that there are 7 points that we can open for discussion on, at least that were proposed for a revision from Nick, okay? So, let's just start back in front, at the top. In the very first paragraph, the one that's listed as paragraph number 2, midway down, the revision being talked about here is to strike the word identified. That's midway through
The second line.
the 7th line. So the sentence currently reads, individuals who identify as transgender or gender non-conforming have the right to indicate their preference to be searched by either a male or female identified officer. And the suggestion here is to strike identified from that. Is there any comments or suggestions on that? Does it seem okay? Okay. All right, the second one was, this is in, well, it's the sentence listed as number 2, under surveillance and privacy. And right now it reads, police may not engage in an undercover capacity with groups in non-public places based solely on the exercise of First Amendment rights. The suggestion here is to change that from rights to protected activities. So maybe it'd be worthwhile to first, do you have any comments on that, Madam Cicilla?
I don't yet. Nick shared that suggestion with me earlier today, and I just haven't really had time to think, research, or consult with any other attorneys in the office.
Sure.
We actually had that language originally and we lost it. So from our perspective, it's probably good to have it back. Being both a plaintiff and an attorney in some First Amendment cases, that's a better language to describe because it's not so much, although actually, just in terms of how it sounds, exercise of First Amendment protected activities, though, you might want to change exercise, actually. I'm just realizing seeing it written, based solely on, just because you don't exercise activities, right, just grammatically. So if somebody's got a better word grammatically, that's probably good.
Probably something along the lines of engaging.
Yeah, based solely on, and then it's still grammatically functional.
We could just strike B and make it based solely on engaging in First Amendment protected activities.
Yeah, it's a little chunky, but it's better.
Engaging in
Or the practice of First Amendment, yeah, engaging in.
Okay, so as a discussion point, what we're looking at is changing it to police may not engage in undercover capacity with groups in non-public places based solely on engaging in First
Yeah, it
Amendment.
still doesn't sound right grammatically.
Practice of.
Yeah, based solely on the practice of First Amendment protected activities.
So, so I think we need to work on the wording specifically. So, yeah, it is grammatically correct.
Or even just based solely on First Amendment protected activities.
Okay. Solely on First Amendment.
Yeah.
I say that, based solely on First Amendment protected activities. Yeah, just take out the verb.
Okay.
So we can ask the journalists.
So, yes, so what we're looking at here is police may not engage in an undercover capacity with groups in non-public places based solely on First Amendment protected activities. Based solely on
Their engagement in.
Based solely on the participation in.
Based solely on individuals.
Based solely on exercising First Amendment protected activities?
Yeah, but that was like, you don't exercise activities. So you read those laws and you're like, why did they do this?
Yeah, got it.
I'm glad that the discussion on this is around wordsmithing, so,
But
Kate
the
and I
concept-
sit down, maybe some other attorneys too, we'll figure out the right way to phrase this, but we're all okay with the general trenches.
It's the English.
Yeah, it's about calling a sixth grade English teacher and finding out the right way to do this.
Yeah, and Sean, if you think there's anything that might speed up my process on rights versus protected activities, let me know.
Yeah, I mean, it's just sort of more, it's the description of what, yeah.
Okay, thank you. The third point here was in the final excerpt here, which is listed as number 5. Right now it says, police may not photograph individuals under 18 years of age, and then it continues. The suggested revision is, police may not photograph individuals confirmed to be 18 years of age, and then it continues. So, any comments or discussion points on that?
On page 5.
No. Right, no, I'm fine with the confirmed to be. I'm just asking a side question.
So is it a friendly amendment to add the confirmed to be?
Yes.
Yes. So, okay with that? Okay, we'll flip over the page. Top section, listed as number 8. No police officer shall identify any individual as a member of a gang in any list or database maintained by any law enforcement agency, nor in any written notes, reports, memoranda, or other document without identifying criteria for inclusion, and then it goes on. The suggested revision here is to remove nor in any written notes.
Will we leave it in the
Oh,
nor in any, we would scratch written notes, and then it would go on and continue.
Okay.
Reports, memoranda, or other document.
okay, so remove written notes. Remove written notes. Any chief?
I'd like to just qualify the concern, this was one of my original concerns. So, It happens more than you think, where we have gang activity and there's either violence, knife activity, or gun activity, where individuals will be in a car and will transport someone quickly to the hospital before the rescue arrives. And it's very important to know if we have a stabbing or shooting victim or someone beat very badly. And oftentimes, they literally pull up in front of the hospital, open the doors, put the injured individual on the ground, shut the doors, and take off. And a lot of times, hospital security, or if the police get there quick enough, will stop the car and identify who was in the car who dropped the injured individual off. That's important. So, oftentimes, we're reading reports that it was Brian Principe, Hugh Clements, and Nick Freeman who dropped the individual off. They were in a 1999 Taurus, and described the car. So if the individual who was injured is a YSB member or an identified gang member, it's important for us to identify in written notes, or maybe even in a report, that the injured individual was shot in front of 43 Hanover Street, and we know that to be a gang location. And now we know the individual who is being treated for a gunshot, stabbing, or beating is on our gang list. It's important for an officer to make notes who dropped them off and what involvement they had in this activity. We fully get it, and I spoke to the commanding officer in the gang, Sergeant Desitals. The last thing we want to do, so I think we're thinking alike, the last thing that we want to do is put an individual either in notes or on paper who's not a gang member, who just happens to, could be his brother, could be his cousin. And I know that's the premise there is, look, because my brother's a gang member, every time I get stopped in front of my house with my brother, I end up in some report. We want to get away from it, and we agree. But we don't want to lose the avenue of still identifying individuals. So if we have a young kid, and we talk to a lot of the gang members who say, well, my brother's 17 years old. And our gun task force gang guys, they get along very well with a lot of the gang members. And they'll say, Johnny Jones, 20 years old, he knows his brother is with him a lot. And he tells him, look, I don't want you to get caught up in this game, in this life. But when he's with me, and we're just riding down the street not doing anything, now granted, we're on a corner, and there's an incident, there's a fight, there's a large party, there's shots fired at the house, at the least, or something worse, we should be able to identify them, and that should count for, I mean, if Hugh Clements is with his older brother 4 times, shots fired, a large fight, and then once he dropped off a kid at the hospital, that should count as, number one, associating with gang members, or being around activity. That's our concern.
Sure.
Okay, you're completely, with all due respect, Colonel, you're completely, I think, and it's probably our fault for not having taken the opportunity, well, we did try to meet with you a number of times, to explain this, but what you're describing completely misses the point of this entire section. You can say anything you need to write, any notes you need to write. I can write in the notes, victim was dropped off by Colonel Clements and Kate Sabatini, both known to be members of XYZ gang, right? With them was Councilman Principe.
Right.
I can say that. But if I don't know Councilman Principe other than associating with you, which is one of the criteria, you can't say he's a gang member because he's associating with you two. You can say he was with you two, and then you could even put gang member, question mark, because you want to remind yourself to, because you would remember, but remind yourself to go back and investigate, remind yourself to check with, somebody else. That's fine. This says you can't say with gang members, Hugh Clements, Kate Sabatini, and Brian Principe, because you don't know that he's a gang member. That's all that says. It doesn't say you can't. So that's not, and here's the reason why I'm flipping out a little, and I apologize, because that was the perfect example that you could still do what you need to do. The issue is, when you have written notes, right, if I'm defending that Councilman Principe gets called into court, you're supposed to, when I request discovery, I'm supposed to get all of your written notes, or not you, because you're the gang member, I'm supposed to get all Officer Yeager's written notes. They're supposed to all be handed over to you, right? No, but seriously, I mean, they never, let's face it, they don't exist, right? So we never get them, but in theory, those should all get handed over to me. That means they also go, the prosecutor has them. Now, the prosecutor wants my client to make a deal, there's that 10-year gang enhancement. I see on here it says he's a gang member. No, they didn't go all through the criteria and put him on the database, but I can use this and kind of squeeze that. He wouldn't have thought about him being a gang member if he didn't see it in the notes. So now all of a sudden, I have to deal with this 10-year enhancement that he's using to try to kind of squeeze some kind of plea out of my client, when beforehand, it simply would have been the prosecutor, like, do you think he's a gang member? Well, he could be, let's investigate that, but it wouldn't be
Understood, and I think we
that
agree.
labeling. You know, and no, I mean, I'm reacting like this because, you know, I'm sorry, go ahead.
And I think we agree, however, I think that's why we're here in the first place.
Right.
That's never been
Okay.
this way, so
Okay.
from our vantage point, that's my concern. And as far as when we go to associations, same thing. So when you go to the characteristics, the list of criteria used to determine inclusion of the gang list or gang database shall be public information, shall be subject to review by the Providence External Review Authority, and shall not include the first bullet, section R, association with other people identified as gang members or any substantially equivalent factor. I think that's a big deal to us. And I'm not saying because one time Clements, his name is in a report, or in Officer Curlin's, or something, Officer Curlin's.
Yeah, I'll apply on next again.
In her notes, that's not even close to being included on the gang list. That's a very small number. So the association with other people identified as gang members, that's the last thing you want to do is put someone on the gang list, or even attach a point or 2 points towards the gang list if it's a good kid who's just with his brother or his cousin and there's no other indication to believe that he's part of a gang. But from my previous scenario, I should come to something.
Kate had something too.
We might be past it. I was just trying to clarify because I sort of felt like we were talking about two different things at the same time. So if I'm wrong, let me know. But I think one is, what are the criteria that are not going to be included, which is what you're getting at right now with this association issue. But the first, which is what I think Sean was originally responding to, was what can and cannot be in notes, reports, memoranda, or other documents. And on that first issue, I just want to ask you, Sean, is it your view that this language as written right now would allow an officer to put in an incident report, so-and-so is a known gang member of X gang, period? Or do they also have to list the criteria?
I think if that individual, and
Is on the
it doesn't say it here, so I have an assumption, which it doesn't actually say here, so, you know, that took us a bit of coffee, that I have an assumption that if the person's already on the gang database, because whatever these, you know, kind of secret criteria, no longer secret are, they've met those, they've, you know, sort of just gone through, thought about it, talked about it, yeah, that person's on the gang database. I don't assume you have to rewrite. I mean, I would assume you don't have to rewrite it every time, although I guess somebody could try to make that point.
Okay.
But, so maybe we want to clarify that. It's more that saying so-and-so is a member of a gang.
Yes.
Because it doesn't say you can't put might be a member of a gang, we're not sure, or hangs out with gang members. You could put or drove up to the hospital with 2 no gang members. It doesn't mean you can't put that. It means simply you can't say, you know, if I was like in a position of authority in a gang, I don't want somebody saying, you know, you can't decide that she's in my gang, right? It's not your business to decide.
Yeah.
So I think that a lot of this here is getting back to the line I was suggesting we have in this, which is that, you know, reading this flatly on its face, I don't think it does prohibit someone from saying gang member question mark in the notes right now, or in the examples I was describing, see driving with 3 known gang members hospital, or whatever. But just in an abundance of caution, to make it horribly clear to anyone who's reading this 5, 6, 7, 10, 20 years in the future, to add a line that says nothing in this section shall be construed to prohibit an officer from saying any of those things. I think that would go a long way in making it clear that this doesn't misconstrue in the future.
Before we go to that, because I actually think the last sentence is going to be more controversial. I'm just going to clear it up. I'm going to just propose an amendment that I think will clarify what everyone's understanding of this is. So, I mean, you could still get rid of written notes if you want to, but the other way to do this would be to say, nor in any written notes, reports, memorandum, or other document, and then get rid of the words without identifying and put in unless the individual meets the criteria for inclusion on a so-called gang list or gang database, period.
Yeah.
Yes.
Yeah. Okay.
Because even if they haven't entered XYZ person, and that gets to that, like, if they are in the gang database, do I still have to say the criteria over again? That's great.
So can we do that again? So what we're suggesting here is keeping the nor in any written notes or reports and memoranda or other documents, and then instead of without identifying.
Right, get rid of the words without identifying, replace them with unless the individual meets the, and then, as already stated in here, criteria for inclusion on a so-called gang list or gang database, and then I would put a period right there and strike the words that apply to that individual.
I think that solves everybody's.
Okay, so let me see if I can read this back, and if that's what you were suggesting. Okay, so, no police officer shall identify any individual as a member of a gang in any list or database maintained by any law enforcement agency, nor in any written notes, reports, memoranda, or other document, unless the individual meets the criteria for inclusion on a so-called gang list or gang database, period. Get rid of that apply to that individual. Is that correct? Okay, are there any suggestions or comments or points to be brought up on that? That's great.
Now, I think what Nick was talking about is slightly different, so I don't mean to
No,
close off the conversation on that.
Frankly, I think that more simply in how I get to this, I was trying to get to, so.
You know what, let's give them a minute to let everyone just digest that change. So we'll make sure it's clear in everyone tomorrow. So please take a minute to read it through. If you need for us to, or Kate to say again what exactly it is, we can do that. So just, please. Kate, you want to?
Sure. No police officer shall identify any individual as a member of a gang in any list or database maintained by any law enforcement agency, nor in any written notes, reports, memoranda, or other document. And then after the comma, the words without identifying will be removed, and the words unless the individual will be inserted. Unless the individual needs the will be inserted. Criteria for inclusion on a so-called gang list or gang database, period. And then the phrase that applied to that individual will be deleted.
I just want to make a different argument on why this is so important that it be strong. The new ICE enforcement stuff means that if you've got any connection with any gang that's in police records, if you get detained, even if you're a DACA youth, and that comes out, you're out. It's huge. There's less room for mistakes.
In our internal policy relative to the immigration issue is pretty solid in reference to comparison to other municipal urban areas around the country, similar to the demographics of Providence and LA. So that's not our intention.
I don't know if it's anyone's intention, but there have been a couple of youth that have picked up. And if they're DACA youth, they've gone through a background check. And yet somehow this kid got labeled as a gang member from some old police records. and one got deported and one's been
Always.
bailed out, is last couple months. It's the new ice age that we're in, that has has more disregard.
Was he a gang member?
No.
So how would they get that information?
It was in some old records that he was listed on the gang list.
Records?
Yeah.
Okay.
You know,
Point made.
like 10-year-old records.
Yes.
So I guess,
Justice.
yeah, thank you, sorry. I guess my only, not really concerned because I do think this covers what we're trying to get out for the most part. My other concern is, so like, this doesn't really protect folks in the sense of it says like if they meet the criteria, but we still, so like if an officer knows they meet the criteria but they're not on the list yet, right? And we're like, if they're not officially on the list and they write, oh, this person's a gang member, then that's my concern. Does that make sense?
Yeah, let's talk that through.
So there's a difference between someone who's like on the gang list and then you're like, they're a known gang member, so you're like, this person is known on our list already, versus someone who's not necessarily on the list, but may be subject to investigation and put on that list later, who then, because they're technically meeting the criteria, even though they're not officially already on the list, someone can jot that down and put that in a report, even though it's not confirmed yet. So, and that's my concern, is that's why I think like that was who we were trying to get to. It's like you can't put you can't identify someone as a gang member who's not already on the database without identifying why you're now identifying that person as a gang member. Does that make sense?
So, what if plain language dictates apply? Instead of it being unless the individual meets the criteria, what if we made it unless the individual is already on the gang list or gang database, or the officer is listing criteria to place said individual on the gang list or gang database. So that way, if they're currently on it, you can just say, known gang member, so-and-so. And if you're observing and you're gathering information and now you say, okay, I've seen him do 3 of the things on this criteria, this guy qualifies now, I say, all right, Nick Freeman, and then you describe the qualifying criteria as a way of trying to show whether or not this person belongs on the gang database.
Reasonable to, sorry. Is it reasonable to include, if someone's not a known gang member and they're writing their notes, you just put a parenthesis and put the reason why they're listing the person as a gang member, or put a question mark on the criteria that are in their mind.
You can cover that in the official police report, put it in your notes. People take notes differently, and we can try to put that out there. But as far as an official document, we can cover that in police reports and official.
Yeah, but that,
Please, go
oh,
ahead.
no, I had her
I was
name.
just going to respond to Justice's question, and I mean, I would actually defer it back to Mark and Shauna, because I understood your concern as being more, does this person meet the criteria or not? Not so much whether or not this person is or is not on the list, but I don't, it's really up to you whether you think, because, right, it's really about whether or not they meet the criteria.
Yeah.
I don't know that, and the Colonel would be able to better speak to this, whether, all officers would have within their sort of knowledge who is or is not on a gang list. Like, if someone hasn't made it to the list yet, I don't think they would know that, so that would be my only concern about differentiating in here. But that's, back to you on what's more important, the criteria or the list.
Chief, and I understand your concern, Justice, and it's a good point. But with this new format we're going to have, all officers will know. They'll be able to tap a few buttons and identify. We have 21 gangs in the city. Who is on this list? Gang A has 21 members, Gang B has 100 members. And they'll know. They'll be able to say, oh, I have Prince of A stuff. think he might be in this gang. No, he's not. However, he was there, we just had a fight, our kid was stabbed. So I'm gonna put in my notes, you know, I've been seeing him a lot lately in a couple of car stops in the areas of concern. And he was just at this large fight, so I'm gonna put it in my notes that here he is again. But they'll be able to know he's really not an identified gang.
Yeah. So I wanted to sort of bring in the practicality. So, you know, I hate to be sort of the utilitarian pragmatic ones, but when we're talking about written notes and field notes of an officer, I wonder how enforceable some of these things are really going to be ultimately. I mean, if we were to change this and write specifically, even in written notes, you've got to include all the qualifying criteria, and it's got to work out this way, I think we're ultimately going to end up in a situation like that is that we're not going to see those notes. You know, I mean, it's very hard to, in the moment, make sure that somebody is writing things down exactly the way this is, especially if you're in the field, in your car, observing something, and then they start to drive away, and you gotta go. So I'm not, again, I use the term micromanaging when I started talking at the beginning of it. I understand the importance of the written notes and what they can be used for and what they can be shared, but I also I want to bring that practicality aspect back into it, because we are talking about field notes, we're talking about people who are in the field observing what's going on, and I don't know how much we really can.
Sure.
Yeah, actually, I mean, I think that gets to it, and I mean, I wasn't kidding when I say, you know, I have never received an officer's handwritten notes in discovery, even though legally, constitutionally, they're obligated to turn them over. And I don't know what a defense attorney is still got, right? So it's kind of, will anybody ever see those notes? Who knows? So it's a little bit hypothetical. I think my concern when I first heard about this potential change and the thinking behind it is that sort of the core of what we're trying to get to, and we are, I guess, sort of getting a little, maybe, I don't want to say nitpicky, but we're getting like sort of into things that probably won't play out in reality that much no matter what, is that just sort of the approach to profiling, and again, what we've been calling gang profiling. And so the idea, you know, that an officer's going to want to put it in their notes because Nick is hanging out with Duncan Bay and Justice, and therefore, you know, Nick's probably a gang member because they are, is to get at that thinking, right? And so if it becomes important to be able to put that in the notes, then it's sort of that just shows we haven't really been able to address the thinking. This would be easier, you know, once we get to the point where we know what the criteria are. And so that's part of what we're dealing with, this sort of mystery process that we don't know how it works or what the criteria actually are or will be going forward. So maybe, I mean, as long as we have it clear that here's the concept everybody's supposed to follow, and it is pretty unenforceable, let's face it. So maybe it's, we don't have to cut it so fine.
Okay. Chief? I agree completely, and that's why we originally wanted to take out any written notes, because you're not able, you don't have the ability, technically, you haven't gotten those written reports. But I think we can craft the language in such a way that none of which you are concerned with ends up in official police documents that could be used against the individual for reasons that you're very concerned with. So how we word that is still up in the air. Like Kate's suggestion, but how do we get back to written legislation?
Sid?
I just want to say for Sergeant Bohm's not here, and we had lengthy discussions about these and other things, and one thing, and I can't speak for him, but I can suggest that what he was open to was incorporating some of this stuff into the training, and he was really open to working with folks about because what you're saying, the part of what you're trying to get to, you don't want it to get lost in these technicalities that will hamper people in doing their work, but you would like to see the training element of trying to eliminate that profiling piece or that instinct, you know, and he has definitely mentioned a willingness to kind of discuss, you know, what could be better in training, since he does all the training. So I know that there's an avenue open there, so there's another way to get to that as well. So it's not, you know, they're still at the table, and as well with the transgender issues and that kind of thing. And I found that he's been very open to incorporating that into training, and they want to do better. So the only way they can do better is with those lines of communication open. So I think it's an important part of the process.
Okay.
So then I got thank you. I guess my question to, when is it necessary to identify the criteria? Because I think part of the language is in reports, in the more official documents, sometimes that criteria would need to be identified because you can't necessarily, even though like an individual can appeal their inclusion on the gang cannabis list, like, you know, other people can't just look it up, right? Like a lawyer can't look up why someone's included on the list, right? So if you are a defense lawyer and you don't have access to the criteria for why someone's included and that person didn't previously appeal or anything like that, then does that criteria need to be included in official documents?
I think the way it could play out then is, I mean, when you'd be able to get that even if it were just having the person do appeal or, you know, requesting the appeal on their behalf. So at that point then, you'd be able to get that information. You should be able to get it quicker than you're going to get discovery most of the time. But in time to, you know, be able to know what they're saying. And I don't know though how long an appeal would take, though that could be an issue. I mean, maybe.
I believe in another section of the CSA, we said that the appeals would take place within 30 days or so.
Oh, right.
So,
Okay. Does that help clarify things? It does, okay. Any other points on this matter? So, where are we with it?
I guess my first question is, strike written notes or leave written notes?
Okay, what do we say about that? I think, correct me if I'm wrong, Chief, you're suggesting we strike written notes still, or keep it in?
I was comfortable with kids wording that. I also did striking written notes. That was the original intent for all the reasons we brought up, and I know that was Sergeant Bones' original point on this. Mine was more the association alone written notes, because we don't want to lose that ability.
I checked with at least 10 people over at PRISM today, and people were not comfortable with taking out written notes. I mean, even if there's no way to enforce it, but at least with the idea that that's the thinking. Yeah, I think it would be hard for us to, we've given up so many pieces on this, you know, over the years and recently, that it does seem like that seems to be one that really kind of keeps the essence of this section that folks felt pretty strongly about. The change does seem to get to that criteria, so I would strongly recommend keeping written notes in.
And I'll just say, with Kate's additional language, the scenario that I posed is still acceptable for the police, you know, with the lives disturbance. And Brian principally isn't on the database list, but he's there. And he's at the hospital on fire.
with that, sorry, with that, you'd be able to write exactly what you're saying.
Make written notes.
Yeah, you'd be able to make written notes about that as long as it's clear you're saying,
He's not on the
he's
list.
not on the list, these other people may be, this person.
Well, I mean, you know, again, because we don't know, because it's all been top secret, what the criteria are, I don't know if anything in the scenario you described would mean he meets the criteria. If he met the criteria, they could put, you know, you think he's a gang member because he meets the criteria. You know, but, you know, we don't know that from the scenario. And just hanging around with that because association can't be one of the criteria. You know, there's also a million other ways they could write it, say, we always see him with these guys, question mark, star, you know, whatever different people do in their notes. Is he a member, question mark, you know, however they wanted to, you know.
And at the scene, and that's all they are.
Principally, he's here again, you know, exclamation point, you know, it's notes, but not like Principe, member of, you know, let's be aware.
This why we're more on the issue. We don't want to lose the ability, and this strikes right to the core of our responsibility in the community.
But if you have, if the officer has reason to think he might be a gang member, why can't the officer just say that he might be a gang member? If he doesn't know that he's a gang member, how can I say you are Seventh-day Adventist? I can't walk around saying, I saw him go to church on a Saturday once, Martha. He's and I've seen him hang out with some Seventh-day Adventists. I don't know that. You see what I'm saying? I could say he might be Seventh-day Adventist, question mark.
Okay, Chief?
So I would say the officer shouldn't say he might be a Seventh-day Adventist. However, what you might say is that, once again, he's in the company of
Sure.
this group.
Yeah, that's
Once again, he dropped off a member who was staff of this group.
Yeah, absolutely.
Okay.
Yeah.
And again, the language, including what Kate added today, that would all be allowed, that would all be fine, but then you couldn't say, we saw him again with these people, therefore he's gay, unless he met the criteria for inclusion. So I think that what you're describing would be fine, but I just want to be clear.
Before we were getting into this, that would explain it.
That's why we're.
Okay, it sounds like we're on the same page. Is that right?
It's just hard because it's so hypothetical when you don't know what the criteria are.
Okay, further conversation.
So before this session is over, we'll try to get you what we're looking to use as criteria to incorporate something.
Okay. So do you have what the revisions are for this?
So just to be formal about it, so is there a friendly amendment to change it to read, no police officer shall identify any individual as a member of a gang in any list or database maintained by any law enforcement agency, nor in any written notes, reports, memorandum, or other document, unless the individual meets the criteria for inclusion on a so-called gang list or gang database. Period.
Everyone? Looks good? Chief?
Looks good. However, as Kate pointed out at the beginning, we're kind of talking about two things. And that one issue, it goes back to section 9. List of criteria used to determine inclusion on the gang list shall not include association with other people identified as gang members.
Okay.
So, the mere fact that my principal, that will be one of the things that we are strongly looking to use as criteria in a very small way. It doesn't mean the mere fact that you're with gang members at the scene of a shooting that you're not part of a gang. However, there is data out there, empirical data. There's been studies, I believe it was done by Rutgers University, that absolutely states those who hang with others, even though you don't carry a gun, if you hang with an individual who carries a firearm or a knife on a routine basis, you are more likely to be shot or be injured in a dispute. You are more likely to be a victim at some point. If you hang with gang members on a routine basis, you are more likely to be a victim.
So would it be worthwhile to perhaps take that section number 8 and make that one of the items on our next agenda to talk about? Sean?
I have to say I'm a little bit stunned because that has been vetted over and over and over again. And this is even more than getting a bunch of objections during the last month. This is really last hour. And that one is huge because when you listen to the testimony of young people, particularly young people that have been profiled, that have been, accused, attacked, and labeled, that's the hugest factor. That's why this has been in there from day one. That's why, in all the conversations, all the meetings, all the discussions, folks were very alert to any possible attacks on that section. And we're going right from here to a meeting of folks, and if we come back there and say, oh, guess what? there's one more change that we haven't heard about, that nobody's brought up ever. I mean, I don't want to speak on behalf of other people, but I can just tell you there will be a lot of unhappiness.
Well, that injustice.
My recollection too is that there was some trade-off of you took out physical characteristics and left that in. So no one could define what they meant by physical characteristics.
Justice, do you have something?
Yeah, so, and also, like, I know you suggested putting this on the next agenda, but I think one of my concerns is that, like, from even what you just cited, that information, that sounds like if someone's associating with a gang member, they're likely to be a victim, which is a protective issue, but from at least my understanding of the current gang list, that's a list of people who are gang members, not a list of people who are vulnerable due to relation with gang members, so that still doesn't make sense as a criteria for inclusion in the gang list. So unless the gang list is just broader than we thought, it also includes people who might be vulnerable due to associations with gang members, that does not sound like a good reason to have someone on a gang list, because that shows that they're more likely to be a victim, not more likely to be a gang member.
Thank you, Nick. So just sort of procedurally, the section that we're discussing right now wasn't on the agenda for today's meeting.
Oh, right, so.
I just want to put that one out there. I'm okay with adding it to our agenda for the next meeting or whatever else. It's something that people, if they really feel strongly about discussing it. But I just didn't want to sort of procedurally point out that that's not tonight's agenda. So which always the.
Okay.
I mean, it's part of subsection 8, so I think we're fine. But, so I'm just saying, we have not violated the Open Meetings Act, but, but that said, if people want to kind of pause and talk about it, I'm just saying, I don't think we're violating the law.
So, would it be helpful, now, the chief had mentioned getting the guidelines and criteria out there, and would it be more beneficial instead to put that on the agenda to let that be a point of discussion in the next agenda?
I think if it is, there's going to be some incredibly unhappy people. If that comes up, those, like I said, those have been vetted, they've been, discussed, analyzed. Micah pointed out, it was at the Good Friday meeting that the physical characteristics was let go of, one of the many points that the coalition conceded on in terms of being able to keep those other criteria. And for that to all of a sudden, again, sort of like, boom, come out of nowhere, folks will be, I'm predicting, I'm extremely unhappy.
We had a conversation at the beginning of our meetings about whether it's substantive change or change of intent, or what. I think that's a change of intent.
Yeah.
That would put the whole thing at risk.
Okay, no, I'll leave it to the group. What's the suggestion? Where do we go? Where do we go?
Leave it as is.
So, for the record, you stated that this has never been brought up. I can remember going back to day one, and you're right, we've been at this at every one time. If you remember the meetings maybe 2 years ago, at prison, and this came up back then.
I think we're thinking back to the negotiations around the table this year.
Okay. So, I would suggest that, and I thought that's what you were identifying, that we bring our list of what we can include, so we can further discuss. So you can say.
That's what I was suggesting, but I'm leaving it open to discussion of the group. Yes. Sure. Justice. Okay, Justice.
I was going to say, I do think the suggestion of bringing the criteria that would want to be included or what's currently included would be useful to see. I think that would give us a much better understanding of how to deal with these changes as well. I don't think that the association factor is something that could be changed. I think that is substantial. And I think it's listed in that subsection as number 1 because I think from the testimony we've heard, both at the public hearings and like through just developing this, that was probably one of the biggest reasons the whole community's part is in here. That's a huge part of it. So I think that's a change in purpose to the document that we wouldn't be able to do. But I do think figuring out what criteria is used is very useful, and also understanding changes that were made before, or understanding how the things we're talking about now will affect the database.
Sean?
And I was just going to suggest in terms of sort of procedure, definitely folks, I mean, for 10 years have been wanting to see that, at least speaking, for folks in prison long before I was there, have been wanting to see those criteria and would be very happy to finally see those and have been asking for at least 10 years. It might be just more smoother and procedurally work out better to get the CSA stuff done first and get the legislation wrapped up and finished, and then as sort of part of the, okay, how do we move forward and educate all of us, the community, the officers, other players and actors. That would be an important piece and really helpful, but it might be easier to just get the legislation passed first.
Okay, so you're suggesting that might be a better next step in the interim from potential passage until implementation.
Yes.
I also just point out that one of the other things that's in here now is now a review 6 months after implementation. So on January 1st when it will take effect to talk about it, and then any issue that come after that will be another 6 months to review that. So there's a couple extra review points in this.
Okay. So it seems like we have agreement on the wording that we were going over, right, with the most recent revision. Going back to that. So are we okay with everything else right now on this section, Justice?
Sorry.
It's okay.
The one thing was with the appeals thing, this doesn't say, okay, unless I'm reading this wrong, it doesn't look like the appeals for the gang databases have to be finished within 30 days, they just have to be scheduled.
Oh, sorry, you're going down to the next part, Justice. Yeah, so we have to be scheduled within 30 days.
No, in reference to what you were talking about, like the lawyer get the information.
Right.
Yeah.
So once you file for that appeal, then the appeal has to come within 30 days. We started within 30 days.
Okay.
So that's what I was trying to clarify before. There was a time. It wasn't going to drag on for months or something.
But we don't know what
just for sake of reference, where are we
that's in 10.
Oh, 10.
10.
Oh, okay.
But it's in relevance to what we're
Relevance to- okay,
yeah,
fine.
because so the hearing has to be scheduled within 30 days, but it doesn't have to, when does it have to be finished? We don't have that.
So it's specifying a start date, and you're wondering if it's also specifying when it needs to be finished on an end date.
Yeah, which I guess you can't necessarily specify, but I just wanted to point that out because we brought that up.
Yeah, I think the idea there is that, we would hope that these appeals would not be long drawn out processes, but just given that we haven't done these before, we're not sure how long that would take. So to say they have to be scheduled within 3 days is to make sure that it's happening properly and somebody isn't just hung out there to dry for a while waiting. But to put an end date on it has to be done by, I don't want to cut short their appeals process if they need time to do more work or whatever.
Okay, cool. So, I'm sorry, did you have something?
I didn't.
Oh, okay. Are we all set with 8? And can we move on to 10? Yes? Everyone?
So, yes, similar on my side, I'll go back internally, and I thought I would kind of connected my original plan as well as the association. Sergeant Bowman, that was one of his concerns, he's not here
On 10, so from what I gathered on this, it seemed like it's more of a theoretical, or the question is, so what's the path forward for health, right? You just mentioned that there would be, so we know that there's a review once PARA is re-engaged, but it's a matter of how is PARA going to get engaged, right? Is that what you were
Yeah, that's what I'm
indicating?
So, I mean, the PARA ordinance was established, I'm not sure what year it was created, the board functioned, it existed in functioning for a number of years, survived court challenge against it, and then over the years it became dormant and basically stopped functioning. Since then, the ordinance has been revised at least once, and it passed, but the board hasn't really been reactive, it hasn't been active in years. So a lot of what's in the CSA puts responsibilities or gives authority to PARA, which as of right now is a dormant board. So, one thing that everyone's been consistent with, at least in every meeting that I've been in throughout this process, has been the need, it's incumbent on the city to reactivate that civilian review board. And PARA is, or the CSA is sort of the impetus for doing it. Around the country, there's a model that's being viewed as a best practice that, the police departments have a civilian review board as some sort of check, some sort of extra check, checks and balances in the system. So I think that there's generally a feeling throughout the city, it's incumbent on us, it's incumbent on the city to get PARA reactivated. And if and when the CSA is passed, then we know at the time to get it done. Then between this and January 1st, it's incumbent on the city to get that. Now, I think that from my conversations with Sergeant Ball, the concern there was, well, we're putting a lot on here, what happens if it doesn't come through? What if on January 1st when this takes effect there isn't a current one? And so I don't know if there's a way to drop sort of catch-all language in here that says something about that, or if we just all have to really commit ourselves to making sure that there are
Any comments or points to be made on that?
It's my understanding that there is to be funding in the budget that helps move that forward. I don't know if that's, the budget's in process, but that's my understanding of the intent from a month or so ago.
I seem to recall that too, in the proposed budget. So I don't think the funding of the board is necessarily going to be the problem. So I guess, is there enough time to reactivate the board and potentially potential approval of this until the beginning of next year? I think that's what, right? Yeah. So I think you're right, Martha. So that definitely helps, right? That definitely helps.
And then it's a matter of appointing people to recreate a new board. Okay, and then it has to start working.
Yeah, because I have that concern too, but I also don't think there's a way. I think Paradise has to be up and running, right? Because there's really no other board or other body that we can put this. We can put this where we want to. So I think it has to be made functional again for this to hold weight, because there is no other body that could be trusted with this work anyway. It's not like there's another civilian review board that would be used. So,
and the other thing I'll say is that just because we're talking about the CSA right now, it wouldn't really be appropriate to drop in suggested changes or ideas for how PARA should function into this ordinance. That should be
That makes sense. That makes sense. Councilwoman?
Similar to what Nick just said. However, timing is everything, because we're in the budget season. Without a budget for PARA, a real budget. A budget is, we have been talking about as connected to the police department. Without that budget, this is, I don't see no other word other than it will work. And so I think that's the urgency that I feel with the anxiety, is the fact that the longer we allow the budget season to continue as it is and work with this particular piece of it, it just slows down what the next step would be. And so I guess I'm a little bit anxious around that, just to let you know. I'm appreciating the work that is being done on this, and the fact that we had to come back in order to make sure that we're including all the voices. But that is a big concern for me. I am counting every day, and every day when I count, I'm getting more and more anxious. And that's just really concerning. I also have a question, once we have amendments to the basket to go forward for the second vote, what is the next step after this committee is done with these amendments that have been worked on? What happens now? What happens to get it back to the council? Is there another step that needs to be taken?
My recollection is that the resolution requires us to report back to the committee on ordinances.
So we have to vote again?
Well, you mean on the ordinance?
Yeah.
No, because the ordinance is still pending before the full council. Am I right?
You're correct.
Yeah, okay. I'm like,
That's correct.
so it's a little funky, right? We're going to kind of like report back to ordinances, and then presumably ordinances is going to refer that back to the full body, and then at that point, you would take up this, this ordinance again on second passage.
That's scheduled for June 1st. Ordinance has been laid on the table until June 1st. Myself personally don't want to be the skunk at the wrong party, but the ordinance probably should have really gone back to the committee. And then this, depending upon how extensive these are, should have been, approved by the committee and sent back out for second passage. But it is what it is right now. And obviously, see what happens when the ordinance does. But the ordinance is kind of in a funky place, for lack of a better word, as Kate said, because normally the report goes to the ordinance committee, or ordinance committee that gets the report, and then implements the changes agreed upon into the ordinance, votes it out and sends it to the floor. But again, it's kind of in a limbo kind of place, and I know that nobody wants to hear that. But,
I appreciate that, because it's sort of where the urgency that I sort of feel.
yeah, and there's nothing that, I'm sorry.
I don't think it's insurmountable, it's just different.
It's different.
Sean?
Yeah, I think when we were wondering about all the procedural questions when we entered into this phase of things, it does seem pretty clear that it's okay to do amendments from the floor as long as that whole part that's laid out in section 409, it complies with that and doesn't change the original purpose. So I hear what you're saying, that it would just be more thoughtful and a better process, a better practice, but it's still, well, it may be funky, it's legit too.
I mean, the thought process could be if there's a report that goes to ordinances, then ordinance committee can get the report and go through the report and then make those changes on the floor. Again, it's a little part of the course, that kind of thing, but it's not something that we can't figure out.
Yeah, and I think that's the theme that we need to go with here, is that although we may not see it all the time, it may not be, it may be funky, but, it's something that, but you can tell where I am. But I think the important note here is that it's not an insurmountable matter. I think we can work through this and move forward with what we're looking to get done.
Just if I could about the para, I know a long time, and I thought the para was not a committee that was under the jurisdiction of the clerk's office at the time. Some of the people in our office were kind of lent out to para to help facilitate meetings. And the problem with para is that the first inception of it was there were so many people. I think each council person had an appointment and there was so many from it was such a huge committee, and it was
So,
bigger than that.
if I may, before we move on with this, so I want to come back to the conversation we're having here. And to get to your point, Councilwoman, is that the Finance Committee is vetting the budget pretty much as we speak. And the council will get the budget out in a timely fashion in order to properly compensate. Okay? And I think I personally haven't heard any kind of resistance to making sure that PARA is going to have the funding it would need in order to operate properly. And then, so if we can put the funding portion aside, it's then a matter of making sure that PARA itself.
And that was my point.
Yeah,
They
it's
just
something.
couldn't get off the ground
Yeah,
first.
and that's a matter we're gonna have to take up. That's the interim.
No, in all fairness, he's
Please, it's okay.
it was held up in court, and the functioning part of it could not function because it had a court order against it.
Correct, and then people dropped out, but there was report one person left and the other.
But it's a different format, right? So,
Yeah.
Nick.
But my
Oh,
suggestion
I'm
was
sorry.
that was just that the appointments would have to be in, getting their director and all that, and kind of hit the ground running, because
Sure.
I've seen a lot of committees not get going quickly enough, and that's to be a
Nick,
concern.
just to quickly talk about the structure of PARA, the clerk is 100% right. The original version of PARA was a very large board. I had the top of my head, it was 21 or 23 members, but it was really unwieldy. It was hard to even put a quorum together, and you've seen how difficult it can get to put 11 together. So, and there was an amendment done, I believe, in either 2010 or 2011. The council passed that reduced it down to 9 members, that changed how the appointment structure was done. So a lot of the issues we're discussing with how the old PARA, the original PARA worked, haven't been. I'm not going to sit here and say there aren't other things that can still be discussed or should be made to make it work as best as possible for the city, but a lot of those issues have already been addressed.
Forgive me if I don't understand exactly what our charge is as a group here, but I think our appointment is until January. Did I see that?
I'm not sure.
No, this is just a working.
Just a working group, yeah, okay.
And according to the ordinance, there's a specific time to report back to,
Okay.
and that would be, once the report has been officially given to the ordinance committee, and then SNLP was.
So some sort of a working group to oversee the implementation when we...
I think if we're looking at time periods right now, okay, we have a time period in which, right now we're together, and that is to review the four corners of what's within the CSA.
Okay.
We have a time period that will be what amounts to an interim time period from the time of potential passage through the time that it gets implemented. And then we have another time period that's after things are really implemented. I think that this current conversation is going to be fleshed out in the second of the interim time period, and that's we can just delve into that as a separate matter and make sure that we're getting things up and running as they need to be. And in the meantime, we'll make sure that as the budget deliberations are being made, that the funding mechanism is an issue, or the funding portion of it. Okay.
Yeah, I want to reiterate, I think, between now and June 1st, we're just supposed to do whatever needs to get done to get the ordinance passed, hopefully completed, so that hopefully everyone's happy, and it's close enough to the original purpose that it doesn't have to go back and go through a whole nother sausage-making process.
Yes.
And then for the summer, it seems like through the summer, June, July, through up until January, there's a lot of different kinds of things that have to happen for implementation, the type of, developing the training that Sid was talking about, other things that would have to get fleshed out. But I agree, I think Councilwoman Harris is right, that parent is the single most important ingredient to make sure that happens, and I would actually be concerned if it turned to like a working implementation committee, because then it's another layer of bureaucracy. But my sense is that everybody who wants this ordinance to succeed is going to be dedicated to making sure that PARA succeeds. The one immediate task does make sense, because once the ordinance was streamlined to make a more effective, workable board, and Miguel and actually Councilman Yurden did that, or took away, I know other people helped, I'm sorry, but that the real issue that sort of has kept it inactive has been money in the fact that it hasn't had a budget and that it hasn't had board members.
Yep.
And if everybody's committed to doing the outreach in the community and recruitment, et cetera, the big thing inside here is the budget. And I'm wondering, would it be appropriate for us as a committee are we able to do a letter as a committee to the chair, to the finance committee, saying how much, just expressing, I guess if they're budget hearings, we can come and testify, but to really put an extra effort into making sure that there's enough money, because in my opinion, as an outsider, and other folks, obviously Councilwoman Harris especially, know more about how it happened, but starving it to death, in addition to the lawsuit delaying things and putting it on pause, starving it to death was the biggest way that it became ineffective.
And
Wait, so then the chief.
sure. I just want to make the record clear because I do know there was a lot of pushback from the very beginning. And in 2002, when that board was established, it worked for a good 2, 3, 4 years before we had a lawsuit. In that lawsuit, that's when people got discouraged. They could not hear cases. It was not operating whatsoever. At that point, the 21 members started to move the board. How do I know that those 21 members were able to be, did lots of work and was able to be retained and did the work on that board? Because I chaired that board at that time. And out of that work, we created bylaws, we created policy. That took like almost 2 years to do. You were part of that. We did it in the police department. In fact, the work that we did it to make sure we was inclusive and making sure that, everybody was at the table. Yeah. And so we did a lot of work in the lawsuit. And that lawsuit, I think that's where we started running more into that problem. And then, of course, yeah, and then
There were reports from 2006, 7, and 8.
Right.
That was not,
Right.
they hired a director, whatever. I mean, my point was that the only point is with a lot of new boards and commissions, they're going to need a lot of support, and they're going to need to get those appointments in and hit the
you
ground.
guys were very important in that first part. In fact, that's how we created all these policies, where you guys were right there with us,
Ellen was one of the really good commissioners.
So, and look, her can be its own conversation. We just have to keep, for the sake of time, and I appreciate the conversation.
Right.
Our time is precious here. So the chief wanted to,
That was my exact point.
Oh, okay.
Fortune for responding to what you just said.
yeah.
Worst case scenario, and they've delayed, or it's not up and running forever, for whatever reason, is separate in this document.
Yes.
So where it says, and shall be subject to review by para. Well, then everything else is enforced in here,
That's
they
right.
just don't review it.
But the intent is for it to be up and running by then, but it's an important but separate conversation.
Right.
Okay? So we may have one more. Okay. Let's just have to do an auditor's report. So why don't you just repeat what you said?
So, under 15 on here, the auditor's report, the intent of this section was just to make sure that it's clear that there will be this annual audit, the report will go to certain people, who the auditor will be, how to be selected, those types of things. It was never the intent of this section that the actual names of the individuals on the gang list would be released or could become public. And so, just to make abundantly clear to everyone that, the suggestion was to add a line into this paragraph number 15 that would read, and again, I'm open to suggestions for this, but the idea was, in the auditor's report, the names of individuals on the gang list shall not be included and shall instead be replaced with unique identifying numbers. So the idea there again would be that rather than saying Nick Freeman is on the gang list and here's the equipment info that needs to be in the auditor's report, it would say gang member 1, 2, 3, 4, 5 or whatever, however the designation would be, just to take the actual individual's name from the list.
That may be so because there was a lawsuit between Dare versus Cannon. All of the names of the officers were redacted. Remember, so
And the
there were
complainant.
700 and something law complaints that were won by their needs here a year ago. That was the condition. So that is stacked on that.
Any other comments?
So is there a friendly amendment to add that language to this section?
Yes.
Yeah, sure. So with the original thing. In the auditor's report, the names of individuals on the gang list shall not be included and shall instead be replaced with unique identifying numbers. And for the clerk, I would say, I think probably the right place for that is before the last line of that paragraph.
That makes sense for everyone? Okay. So, any other comments or points to be made on the items that we discussed tonight? We have another meeting scheduled for Monday, right, at 5:30. Do we want to pencil in another one after that?
I have a question for the staff. How many more meetings do y'all think could be useful to separate the remaining points that y'all like?
Going through it with Sid and the chairman and other various conversations that we've had, I think we were looking at having one more meeting after this, going through the issues that are on the table, and then you could conclude with that. If the group feels that there'd be the need for a fourth meeting to sort of sum everything up, I don't think there'd be a problem with that.
Why don't we pencil it in, all right, and we can make a determination on Monday, okay? So, how about a week from tonight, Wednesday, at 5:30, okay? We'll make sure there's no staff meetings that night. But, you know, we can always say it's not needed, but in the meantime, we can... Yes, that's just one thing. So, yeah, so does that seem to be okay for everyone? And Madam Clerk, if you could just also let the rest of the group know?
I can do that. The only issue
Yes.
from if there's any issues on Monday, I would have already had to post Wednesday's agenda.
Right, so the intent is a cleanup meeting, it's not good.
So should we do as before where folks email individually?
I think what she's saying is whatever we discuss on Monday, we can't.
If there was a concern on Monday, we needed to add it to the agenda on Wednesday, we'd be waiting past my 40 days.
So nothing new.
So, and I just want to question that,
Wait, so we could have a later meeting on Wednesday, right? Could we? No.
Then you'd have to run right back to the computer.
You decided at 6 o'clock or 6:30, then that means that your Wednesday meeting to 6:45. I mean, you can do it. I'm just questioning that.
No, that makes sense.
Wednesday, I'm not sure if there's a way to encompass, maybe just the whole ordinance on Wednesday.
Actually, we could do
Thursday would be better to
Thursday.
give us time to post on Tuesday,
Yeah.
Thursday, and it's just a proposed meeting at this point.
Yeah. So, does that possibility work for everyone? Thursday instead?
We have both nights, we have finance, so that it's actually,
Well-
a 5:30 meeting, probably earlier because the other one was here. So it starts better, so that piece is really specific for us, for posting purposes, we can post on Tuesday.
Does that make sense, everyone? All right, so let's pencil that in, and if you could please reach out to everyone else and let them know what they can.
I'll send a group email and just let them know the next meeting is Monday, the 22nd, 5:30, and if necessary, we're going to have a tentative meeting, we'll send a tentative date for Thursday at 5:30, if there's any other.
Perfect. Okay. Nick? Okay. Anyone else have anything to say for tonight? Kate?
No, sorry, I just tapped my head.
Okay. What's on the outside? Okay. With that, I'll entertain then a motion to adjourn. Motion made and seconded. Discussion. All those in favor? Aye. Opposed? This meeting's adjourned.